Swayam Prabha. Digital India. Educated India.
A of IPC is to be taken as Section 85 and 86 of BNS, and Section 494 of IPC is to be taken as Section 82 of BNS.
Hello everyone, this is Professor Shivani Goswami. I'm teaching in IP University and I take family law. Here I'll be taking, as you know, that family law, it comprises of two parts, mainly Hindu law and Muslim law. But I'll be dealing on Hindu law here. I have 10 lectures here and today is my first lecture on Hindu law. Hindu law, all of you know that it's very vast and we have a lot of acts as far as this law is concerned. You talk about the Hindu Marriage Act 1955, you talk about Hindu Minority and Guardianship Act 1956, you talk about Hindu Adoption and Maintenance Act 1956, then there is Hindu Succession Act 1956 which was amended, and it was Hindu Succession Amendment Act 2005, so on and so forth. So we have number of these acts, but today basically I'll be taking this one by one, and today I'll start with the Hindu Marriage Act. And when we start with this Hindu Marriage Act, the first is the introduction to Hindu law. Now, as we know that, laws could be divided. It could be territorial or it could be personal. Territorial laws are those laws which are applied throughout the territory of India, and they are uniformly and in the same manner applied to every person. So that means whether a person is a Hindu, he is a Muslim, he is a Christian, he is a Parsi, to all these acts are applied provided he is residing within the territory of India. We have Indian Contract Act. So that's Indian. So that means it is equally applicable to the Hindus, it is equally applicable to the Muslims, it is equally applicable to the Christians who are residing within the territory of India. We have Indian Penal Code. So they are same. There are no different provisions for the persons who are belonging to different religions if they are residing within the territory of India. On the contrary, the other one is the personal laws, and as far as the personal laws is concerned, it is applied to a particular class of persons based on the religion, based on their faith, based on their culture. It could be, for example, if you talk about Hindu law, it is applicable only to the Hindus. Muslim law is applicable only to the Muslims. The Christian law, there are so many acts, it is applicable only to the Christians. So we have this Hindu law it cannot be applied to the Muslims who are residing within the territory of India. Similarly, majorly Muslim law is an uncodified law, but now it is becoming codified. We have Dissolution of Muslim Marriage Act 1939. You have Muslim Protection of Rights on Marriage Act 2019, Muslim Women Protection of Rights on Divorce Act 1986. So they are applicable only to the Muslims, and if a person is a Hindu, these acts will not apply to them. So that means if you're talking about Hindu law, they are applicable only to the Hindus. If you're talking about the Muslim law, they are applicable only to the Muslims who are residing. That's just an example. Now, when we talk about this, I have already stated that Hindu Marriage Act is there, Hindu Minority Guardianship Act, and there are so many other Hindu laws. When we start off the Hindu Marriage Act, Section 1, we'll be dealing with some important sections, and first I'll be reading the section and then I'll explain it one by one. So it says that the act may be called as the Hindu Marriage Act 1955. It extends to whole of India except the state of Jammu and Kashmir, and applies also to the Hindus domiciled in the territory to which this act extends. So that means this act, Hindu Marriage Act, it came into force on 18th May 1955, and this is the period when it commenced. That's the date when it came into operation, and it is applicable to all the Hindus within the territories of India. It even applies to people who are living outside, provided they have a domicile in India. So that means a person should be a Hindu in order that this Hindu marriage, because whatever acts are there, whether it is Hindu Marriage Act, it is Hindu Minority and Guardianship Act, it is Hindu Adoption and Maintenance Act, the word that is coming commonly is Hindu, Hindu, Hindu. So that means these are the acts which are applicable only to the Hindus, and now the question is, who is a Hindu? So this means this act is also applicable to the Hindus. I'll be coming to the who is a Hindu in my next slide, but before that, I'm just telling about the jurisdiction of this act. This act is applicable to the persons, Hindus who are residing within the territory of India, and it is also applicable to the people outside India, provided they have a domicile in India. So that means if you are, there are so many people who are going abroad, but if they have a domicile in this country, they have not given up their domicile, even though they are abroad, this act would be applicable on them, because domicile is another important pivotal part under it, and if they have a domicile in India, that means it is applicable to them also, even though they are not living within the territorial limits of this country, that is India. Question here is, what is domicile now? But if you see it, there is no such definition of domicile that is provided under the Hindu Marriage Act. So it doesn't talk about the domicile, but if we go through the various definitions by, for example, the Oxford Dictionary, it says that domicile is a country that a person treats as their permanent home or lives in and has a substantial connection with. Thus, it is a place of residence, abode, house or home, and legally it is a permanent legal residence of the person. There was a case of Central Bank of India where it stated that there must be factum and there must be animus. Animus is intention. The resident needs not be continuous, but it must be indefinite, not purely fleeting. The intention must be a present intention to reside forever in the country where the residence has been taken up. So that means this act is applicable to the people who have, though there is no specific definition of the word domicile, but the intention here is that the person has a permanent intention to not to leave this country, to not to forego this country, not to abandon or flee from this country. So if he has this intention, then the domicile is of this country, and to this person also, if he is living abroad, he is not in India, he has gone somewhere else out of the territorial limits of this country, this act, that is the Hindu Marriage Act 1955, would be applicable to such persons. So that basically the jurisdiction to which this act applies. Now I have been talking about the word Hindu, Hindu, Hindu everywhere. The question is, who is a Hindu? When you talk about, the Hindu Marriage Act 1955, there is no specific definition. There's no, like we have under Indian Contract Act, you have a definition of contract. A contract is an agreement which is enforceable by law. It says so. We have a specific definition of this thing. But when you talk about this personal law and you talk about Hindus under the Hindu Marriage Act, or for that matter, even under the other acts to which this Hindu law is applicable, there is no specific definition of the term. We cannot explicitly and in a very, unambiguous manner clearly define that he's a Hindu. But if we say that these are the persons to whom Hindu law applies, then you can very well envision that these are the person, if it is applying to the Hindus, that means the Hindu law is applicable to them, and these are the person who are Hindus. There is no direct definition, there is no specific definition, but the Act says that these are the persons on whom Hindu law is applicable. As there is no direct definition of the term Hindu, so we look at section 2, which talks about the persons on whom Hindu law applies. And if we go through this section, I'll be reading the section first and then I'm explaining it. This act applies to any person who is a Hindu by religion in any of its forms or developments, including Virashaiva, a Lingayat, or a follower of the Brahma, Pratna, or Arya Samaj, to any person who is a Buddhist, Jain, Sikh by religion, and to any other person domiciled in the territories to which this act extends who is not a Muslim, Christian, Parsi, or Jew by religion, unless it is proved that any such person would not have been governed by the Hindu law or by any other custom or usage as a part of that law in respect of any matters dealt with herein if this act has not been passed. Now, this is an explanation to this particular definition, and subclause 2 says that notwithstanding anything contained contained in subsection 1, nothing contained in this act shall apply to any member of the scheduled tribes within meaning of clause 25 of article 366 of the constitution unless the central government by notification in the official gazette otherwise directs. The expression Hindu in any portion of this act shall be construed as if it is included a person who, though not a Hindu by religion, is nevertheless a person to whom this act applies by virtue of the provisions contained in this section. Now basically this section is not giving any direct definition that a Hindu is this. It is simply talking about who are the persons on whom Hindu law applies. So that means if we take it one by one, break this, bifurcate this section, it says that number one is the persons who are Hindu by religion. Second is when Hindu by religion, that means whose parents are either Hindu, Sikh, Buddhist or Jain by religion. The second is any person who is born of a Hindu parents, when either it could be when both the parents are Hindus or when one of the parent is a Hindu. And the third one, if we divide it, it says that those persons who are not Muslim, Christian or Parsis and on whom Hindu law is applicable. So that's the main crux of this section. So that anywhere we have not found that it is defining as to who is a Hindu. It is basically saying that these are the persons on whom Hindu law is applicable. If we talk about the first part, that is a Hindu by religion. So it says that Hindu, Sikh, Buddhist, Jain by religion, in any of its forms, a person is a Hindu by religion. Now we know that as far as who are Jains, we know that these are the persons who do not believe in Upanishads. They are the ones who discard the authority of God, and they just say that by tapasya you can attain salvation. Then even if you talk about Sikhism, it talks about that God is one and one should be diligent enough, one should be laborious enough, one should be skillful enough, and one should work hard to earn his or her livelihood. These are the different ways of thinking by what they feel that you can attain salvation or moksha. So everyone has this belief that how, and they have their different paths on how you can achieve salvation or moksha. Then these are the persons, any child who is born in this family, whether the family is a Hindu or he's born in a Sikh family or a Buddhist family or in a Jain family, the child is a Hindu by religion. In the sense that, for example, when both the parents are Hindus, the child who is born in such a family obviously is a Hindu. If one of the parent is a Hindu and another is a Sikh, for example, the father is a Hindu and the mother is a Sikh, obviously since these are the forms of Hinduism, the child who is born will be a Hindu. Similarly, so even if the parents belong to any of the different forms of Hindu, because Hindu, Sikh, Buddhist, Jain, they are different forms of Hinduism. So either of the parent could either be Hindu, he could be a Sikh, he could be a Buddhist. If both the parents are Hindus, the child who is born is a Hindu and he is a Hindu. He is born in this family, he is a Hindu by religion. Second, when we say, if you see it, it talks about that it is both when you talk about legitimate child or illegitimate, because the section itself says that it is applicable to both legitimate and illegitimate children. Legitimate, all of us know that they are the ones who are born within the lawful wedlock. If the children are, there is a valid marriage, the children who are born out of such wedlock, they are legitimate children. And illegitimate child is a child who is born outside the lawful or legal wedlock. A person is born in a Hindu family, he is Hindu by religion, Hindu, Sikh, Buddhist, Jain by religion. Second is Hindu by birth. So that means if one of the parents, when both the parents are Hindus, as I have already told, the child is a Hindu. And supposing, let's take an example here. The father and mother both are Hindus and a child is born to them. Obviously, since the parents are Hindus, the child is a Hindu. Because in a Hindu family, the child, a Christian child cannot be born when the parents are Hindus. The child would be a Hindu. Let's proceed further. After the birth of the child, the father becomes a Muslim. And now here, the father is a Muslim, but the mother is a Hindu. The child will still be a Hindu because we have to see at the time of birth. Since at the time of the birth, both the parents were Hindus, the child will be a Hindu even though after his birth, the father has converted himself to another religion because he has become a Muslim now. Now, let's proceed more further. If now both the parents convert to another religion, Again, the child will be a Hindu because we have to see at the time of birth. Since at the time of birth, the parents were Hindus, the child will be a Hindu, irrespective of the fact that after the birth of the child, the parents have converted to another religion. The right to convert the religion of the child is with the parents. Before 18 years of age, that means since the child become a major, before that particular age, the right is given to the parent. In case of legitimate child, it is given to the father, because, and in case of illegitimate child, this right is given to the mother, because illegitimate child is always connected with the mother. So these parents have got a right to convert the religion of the child before the child has attained the age of 18 years or has become a major, because in 18 years only a person becomes major. Second could be when one of the parents is a Hindu at the time of birth of a child. Now it could be that when a child is born, the father is a Hindu and the mother is a Muslim. Now the question is, what would be the religion of the child? Now in this particular case also, we will have to see that because the parents belong to different religion at the time of the birth, since they were belonging to different religion, here the religion would be the way the child is being brought up. Right. In a manner he is being brought up, the religion of the child would be determined accordingly. If he is brought up in a, so it's, that doesn't mean that it is not that the religion of the father is the religion of the child. If the child is brought up in a Muslim manner, even though the child is, the father is a Hindu, the child will be a Muslim, because we have to see how the child is being brought up, and these are the cases when the parents, they belong to different religion at the time of the birth of the child. Now there have been, there was one case also under it, that's Sapna versus State of Kerala, and this, the mother was a Christian and she married a scheduled caste, but at the time of the birth of the child, because the religion of the parents were different, so this girl was brought up in a Christian manner. Now afterwards, she wanted to take up the benefits of reservation, but she was not allowed because she was brought up in a different manner. She was brought up in a Christian manner, so you cannot take that thing. So what I'm trying to say here is that in the case where the children are born from different parents, in the sense when they belong to different religion, the religion would not be that of father, number one, although we say that it's a male dominating or male dominating society. But here it would be seen how the child is being brought up, and that would determine the religion of the child. So that's the thing that needs to be taken care of. Then person who's a convert or reconvert. Now all of us know what is conversion. A conversion is when you are renouncing your own faith and you are adopting the faith of another person. So if a person converts to, as far as Hindus are concerned, we just have one amongst Arya Samaj, and that's a Shuddhi ceremony. So if a person from other religion, he wants to come to a Hindu religion, so that's a process of conversion, and that's prescribed under the Arya Samaj, and that ceremony is called as Shuddhi ceremony. When you have to change the religion, that means you need to formally convert your religion. Here I would also like to add one thing, that a person becomes Hindu. When you are a Hindu, you need to practice it, you need to profess that religion. Even though you do not profess or practice that religion, or even though you might be a totally an atheist person, you are not believing in God, you do not have any faith in Hindu gods, you criticize God, you abuse gods, that is totally immaterial. It is, even though you are totally an atheist person, you will still be a Hindu because you are born in that family. So in order that you need to go to another religion, it is necessary that you need to convert to that religion. So formal conversion is necessary, it's a mandatory, it's an imperative requirement that needs to be followed. And only then the person would belong to a different religion. Then, these are certain catena of cases. For example, then intention plays a very part in this part. There was a case of Perumal versus Ponnuswamy, where, it has been stated that if a person is a firm believer, he has a clear intention towards Hinduism, and he is being living as a Hindu only, and the society or a tribe, they accept you as the member of your own fold, even then you are a Hindu. Right? Second it could be Hindu by declaration. There was a very landmark case of Mohandas versus Devaswam board, where Everyone of us have heard about this Jesudas. He is a Christian, a playback singer, and he used to give very devotional music. He had lot of faith in Hindu religion, and he used to give devotional music in the temple. He used to sing those bhajans also. But the rules of the temple, it stated that you need to be a Hindu in order to enter that temple. Now here this person has declared, because he was a firm believer of Hinduism, he had also declared that he believes in Hinduism and he wants to enter the temple. So it was laid down by the court that when you have a clear-cut intention and you have a faith in a particular religion, you have also declared that thing, then you are a Hindu, and he was declared to be a Hindu, even though the priest and they were not allowing him to enter that temple. Then there was another thing under it is there is one concept of reconversion. I have already stated about conversion, and I have stated that if you have to go to another religion, you need to formally convert to that particular religion. It might sometimes happen that you are converting from Hinduism and you are going to Muslim, you are becoming a Muslim, and you did not like that thing and you want to again come back to Hindu religion. So that means it's a case of reconversion. So if a person, reconversion is also allowed, and it is not necessary that if you are, supposingly you were a Buddhist earlier and you converted to Muslim and now you again want to reconvert, so you have to reconvert to Muslim religion or to Buddhist religion only. You can become now a Sikh. You can now reconvert to Jain, and even though you become like that, so you are a Hindu. Why? Because these are different forms of Hindu religion. So it is not necessary that only from that particular way, if you are converting to that, for example, Buddhist, you are converting to Buddhist, a Muslim, you have to come back to Buddhist only. You can become a Sikh, you can become a Jain, and you are a Hindu, because these are different forms of Hinduism, and in these also you will be a Hindu only. Then another thing under it is that members of scheduled tribe who are Hinduized, they are also, Hindus. It says that the provisions of the codified Hindu law does not apply to scheduled tribes. When we talk about, because Hindu law is a codified law, and since it's a codified law, so the provisions of this Hindu Marriage Act, it's not applicable to scheduled tribes who are coming within the purview of clause 25 of article 366 of the Constitution of India. But to those persons, those scheduled tribes to whom uncodified Hindu law was applicable, so it would be applicable to them also. So to them also the Hindu law would be applicable. Then persons who are, again the third one is, who are not Muslim, Christian, Parsis or Jews. Now it's very clear here that before the act came into operation, there were certain people who were Hinduized, and for them, since they were Hinduized, they were not Muslim, Christian, Parsis, so to them also Hindu law was applicable. For example, Aboriginal tribes, then Chota Nagpur, you have so many Santals are there, Kurmis are there, so these are the people who were held to be governed by Hindu law, and to them also the Hindu law would be applicable. Here I have talked about people on whom, because I have told that there is no direct definition of the term Hindu, but they are the persons on whom Hindu law is applicable. So that means this definition of Hindu, not definition, exactly not definition, because these are the persons on whom it is applicable. It is similar in all your Hindu acts, whether it's a Hindu Minority and Guardianship Act 1956, whether it is Hindu Adoption and Maintenance Act 1956, whether it is Hindu Succession Act. In all these acts, this clause is there as to who are the persons on whom Hindu law is applicable, because under these acts also the word is Hindu and it's the same terminology that is being used here. When we talk about section 3 of the Hindu Marriage Act, it's a definition clause, and various definitions have been provided in order to clarify, because these are the things that would be coming under the act. So in order to clarify, these things are provided, and it's a definition clause. Section 3, it talks about, customs, it talks about district court, it talks about certain terminologies like who are full blood children, who are half blood children, who are uterine blood children. So these definitions are there. It talks about Sapinda relationship, which is a very pivotal part under your Hindu Marriage Act 1955. It talks about degrees of prohibited relationship. So these things are there under your definition clause. When we talk customs, every one of us know what's that, and I would be dealing it also in my later slides because that's one of the major important source of Hindu law. So that I will be talking later. When we talk about the full blood, half blood or uterine blood, full blood are the children from the same parents. So that means real brother and sister, real brothers, real sisters, they are all your full blood relationship. When you talk about half blood, in half blood, the father is same but the mothers are different. It says that two persons are related to each by full blood when they are descended from the common ancestor, and in half blood when they are descended from the common ancestor but by different wives. So that means in half blood the mothers are different and the father is same. On the contrary, in the case of uterine blood, the fathers are different, right, and the mother is same. It could be different in the sense, for example, if the spouse of the person has died, or he has gone for another marriage after divorce, because all of us know now it is monogamy, that is the rule. So since the time of when your one spouse is alive and there is no divorce, there is no death of that spouse, you cannot go for another marriage. So as a result, this is possible only in the cases one of the spouses have died or he has gone for another marriage after the divorce has taken place, because we know that divorce is one thing which brings your marriage completely to an end. And after divorce, the parties are at free will to go and to marry. They're just as good as being unmarried, so they can go for another marriage also. So children who are born from that later marriage, it's a half blood or a uterine blood, brother, sister, brothers or sisters. Now, one very important terminology here is Sapinda, which I would like to explain here because this term would be coming later on under your section 11, and it would also come under section 5 of the Hindu Marriage Act when we talk about the essentials of valid marriage. So that means if two people are Sapinda to each other, and the marriage takes place between these two people, that marriage is totally void ab initio. So that means in order that your marriage should be a valid marriage, it is necessary, it's mandatory, it's imperative that the parties should not be Sapinda to each other, and if they are Sapinda, their marriage is totally void ab initio. That means from the very beginning, this marriage is no marriage in the eyes of law. So that means if it's no marriage, you are not husband and wife in the eyes of law, and there is no mutual rights and obligations, there is no status of obligations between each party. They are not considered to be husband and wife right from day one. Now when I talk about, I'll just explain you as to when we talk about the Sapindas, supposingly, in order that the marriage should be valid marriage, it is necessary that the parties should not be Sapinda to each other. And when we have to see the Sapinda relationship, we see 3 on the maternal side and 5 on the paternal side. Now let's take an example here. Suppose this one is the proposed boy. Above him is the mother. Then it's the mother's father. Then it's the mother's father's daughter. Then it is mother's father, daughter, daughter. Now, if this is a diagram, we have to, this P is the proposed boy and this mother's father's daughter, daughter is a proposed girl. The marriage has to take place between these two persons. We need to find out whether they are Sapinda or they are not Sapinda to each other. Whenever we have to find out a Sapinda, we have to take one side. It could either be from the boy's side or it could be from the girl's side. And we always have to go upwards. So it's a line of ascent. We don't have to, here it will go like this above. And we have to come only midway. So that's a midway. Here also, if we have to see from this, we have to go in the line of ascent from the girl's side also. In Sapinda, we have to see 3 on the maternal and 5 on the paternal side. If the boy or the girl, they fall within that degree, then that means they are Sapinda to each other. Now let's take an example here This one is the proposed. I'll start with the boy here now. I have to find out this boy, can he marry this girl? That is mother's father's daughter. So that means she's a female. Now here, immediately above him is the mother. That means we have to take the maternal side, and maternal side, it says that 3 on the maternal side and 5 on the paternal side. If they fall within that, that means they are subpenda to each other. Now this person we will be counting as 1 degree. This one is the 2nd degree, and this common ancestor, this mother's father in this diagram is a common ancestor, and we have to go till the common ancestor only. So it's 1, 2 and 3. Since she was the mother above him, the maternal side, you can go only till 3. Now since this common ancestor is falling within that 3 degrees, that means this proposed boy is a subpenda to this common ancestor. Now, if we see it from the girl's side, immediately above girl is her mother. It's mother, father's daughter. And she is the daughter of the daughter. So that means if she is a mother, you can again go only till 3 degree. So this one is 1. You have to count that person also who has to get married. 1, 2 and 3. Again, till the common ancestor you have to come. Now this one is also the subpenda to the common ancestor. This one is also subpenda to the common ancestor, and since both are subpenda to the common ancestor, they are subpenda to each other, and the marriage between them is not possible. And if such a marriage takes place, that marriage is void ab initio. I'll take another example here which would be more clear to you. This one again, let's take another example here. This one is the proposed boy. Now above him is the mother, then mother's father, then it's the mother's father, then mother's father's son, mother's father, son's son, mother's father, son, and it's mother, father, son's daughter. Now this one is the girl and this is the boy. If we need to find out whether they are subpenda to each other, it's always degree of ascent that we have to see. And you go from downward to upward till where? Till the common ancestor. The common ancestor here is mother's father. Let's see from the boy's side first. It says that above him, immediate above him is the mother. That means 3 on the maternal side. So that means 1, 2, 3. Now here 3 is coming to an end and the common ancestor has gone beyond that 3 degrees. So that means the boy is not subpenda to the common ancestor here. If you see it from the girl's side, immediately above girl is her father. Father, that means you have to go paternal side. Paternal, you can go till 5 degrees. 1, 2, 3, 4, 5. So it's coming within that 5 range. So that means the girl is subpenda to the common ancestor, but the boy is not subpenda to the common ancestor. And if one of them is subpenda and another is not subpenda to the common ancestor, they are not subpenda to each other. If this marriage can happen, because I've already told, in order that a valid marriage should take place, it is necessary that the parties should not be subpenda to each other. So this marriage between this boy and girl is valid marriage since they are not subpenda to each other. But in the previous diagram, they were subpenda to each other, and if this kind of marriage happens, that marriage is void right from day 1. When the marriage takes place, it is void ab initio. Now, the next is, it talks about degree of prohibited relationship. It is again mentioned under your section 5 and 11 of the Hindu Marriage Act. In these also there are certain prohibited relationship and the marriage between these persons is not allowed. The act mentions who are these relations, and if such a kind of marriage takes place, that marriage again is void ab initio. So it says that if one is a linear ascendant of the other, or if it's the wives of the linear ascendant of the other, ascendant or descendant. Ascendant are your ancestors, descendants are your offsprings. So if you are marrying the wives of these persons, that marriage is totally void ab initio, coming under section 11 of the Hindu Marriage Act. Then it also says that the marriage between the children of two brothers, marriage between children of brother and sister, marriage between children of two sisters, it is not allowed. And if such a kind of marriage takes place, if such marriage takes place, that marriage is again void ab initio, that marriage is no marriage in the eyes of law, and it will not confer you any legal relationship, because that marriage is no marriage. It is coming under section 11, and section 11 of the Hindu Marriage Act, it talks about the void marriage. So such kind of marriage is not allowed. Then when we come to another section, that is section 4, it says that overriding effect of the act, and it says that save as otherwise expressly provided in this act, any text, rule or interpretation of Hindu law or any custom or usage as a part of that law in force immediately before the commencement of this act shall cease to have effect with respect to any matter for which the provision is made in this act. And B says, clause says that any other law in force immediately before the commencement of this act shall cease to have effect insofar as it is inconsistent with any of the provisions contained in this act. Now this section basically is talking about that if any custom usage is prevailing immediately before this act, the act came into operation, as I have already stated, it came on 18th May 1955, and if any custom usage, anything was governing before into operation of this act, and it is the act also provides something on that thing, that means that custom has to go away. It has to be done away with. It is the law, the provisions of this act which will be applicable in that particular case. Similarly, if any other law is there which is mentioned and which was there earlier and now it is inconsistent with the provisions of the Hindu Marriage Act, now after it's coming into operation on 18th May, that means anything after 18th May 1955, if it is inconsistent, it has to go away. It is this act now, the provisions of this act which will be applicable. So that means we always say custom overrides the sacred law. But as far as this is concerned, it specifically says that if it is inconsistent with the law, which is explicitly mentioned under the act, then it has to go away, and now it is this act which is prevalent, which is ubiquitous, which will be prevailing, and you have to go according to this law. So nothing has to be inconsistent with the provisions of the provisions that are mentioned under the Hindu Marriage Act 1955. Then we have section that's an explanation. I'll be coming to the sources of Hindu law. Here I have just talked about the 4 sections of the Hindu Marriage Act, and we have not talked about the sources. Sources are also important. So if we talk about these sources, it could be ancient sources, it could be modern sources. Ancient sources, maybe we talk about Shruti, we talk about Samritis, we talked about customs. When we talk about the modern sources, we talk about legislations, we talk about judicial decisions, we talk about equity, justice and good conscience. Now if you take it, we talk about these are various sources of Hindu law, and we know that Shruti is what was heard. What was heard, and it is usually believed that these are the words of the God. So whatever the Almighty has said, these are the ones which are being put in black and white by erudite persons, by seers, and these are the ones which are coming, and we take it as a source of law. It's a very fundamental source of law, and it contains, we know that there are 4 Vedas under it, the Rig Veda, the Yajur Veda, the Samved and the Atharva Veda. They are in Sanskrit, and Rig Veda is in Sanskrit, and it is really thorny and difficult to understand, because it's not that, although it's considered to be the oldest sacred book, but it's in Sanskrit, so it's very thorny to establish the exact date also. We are not that much precise as to when it came, and there are around 1028 hymns. When we talk about Yajur Veda, they are the sacrificial formulas, and they talk about prose, mantra, and it's a knowledge of that particular thing. Again, there is no certainty as to when it came. Atharva Veda, it's the magic formulas, and then we have ancient Veda, it's in Sanskrit only, and it's basically the knowledge of the melodies, and it's again contain verses, and there are 1875 verses under it. Samved is the last one. It has many layers, and it's considered to be the oldest, and the youngest one is the Upanishads. Then we have Smritis. Smritis is what was remembered. When you compare Smriti and Shruti, Smriti is on a higher pedestal as compared to the Shrutis, and it's basically what was remembered. And we are very much familiar. There are so many Smritis. It could be Manu Smriti, it could be Yagyavalkya Smriti, it could be Narad Smriti, so on and so forth. We are very much acquainted and familiar with the Manu Smriti, and we know that as far as Manu Smriti is concerned, Manu coined it, and he was the one who had both sides. Both sides in the sense he was very much harsh towards women also, but he had a soft corner also. Harsh in the sense because he used to say that the word he is very important and it plays a very pivotal and important role in the life of the women. The women's life always revolve around this word he. The husband is very important. The women should be loyal to her husband, even though the husband is devoid of qualities. He is not that person who has had so many qualities. Even then, the women should obey his commands, and he also has a right to correct women, and he can even thump women. And so these were the things that he had laid down, and it was stated so that it's a male dominating and male dictating society, and women has to be subservient to men. So this is what he stated. On the contrary, conversely, he has also stated the other side also. We all know that it has been laid down that yatra naryastu pujyante ramante tatra devta, where the woman is respected, the god adorns there. So we see the both sides, and he used to say that a person should adopt a girl child, and the father should give the girl child to a noble man who will be the husband of that woman, and adoption of the girl child. So he was having both sides. He was harsh also, and there was a soft corner also as far as Manu Smriti is concerned. Then apart from this, there is Narad Smriti is also there, and it highlights about the procedural and the substantive laws. And then we have Yagyavalkya Smriti. We know that we will be talking about the Mitaksha and the Dayabhaga school later on, and we know that how Yagyavalkya is important. We will be talking on that point of time. Commentaries and digest is another source of law, and it's again a very important source of law. After Manu Smriti, there were a lot of confusion, so because he was harsh towards women, there was a lot of bewilderment and puzzlement was there, as a result of which many interpretations came in, and due to these interpretations, there were a lot of different interpretations, there were a lot of commentaries also. So these commentaries that were being written on, it again played a very important, a very noteworthy, very significant role, and it constituted another important source of Hindu law. So these are various commentaries that you can see on my slide. It says that Asaya on Narad, Vishwarupa on Yagyavalkya, Medhatiti on Manu, Vigyaneshwara on Yagyavalkya. So these are the prominent commentaries. So these are there, a big number of one, so they are really gargantuan. So then the last ancient source is the custom. We are very much aware of custom, and as I've already told you, if you see the custom, it is the one which is being continued followed. There do not have to be any breakage. It's continued from generation to generation. Only then it is as good as a law. So there are certain essential requirements which need to be satisfied, and if these requirements are not there, that means it's not a custom. So the first requirements, when we talk about it, should be ancient, it should be antique, it should be continuous. Ancient, I do not mean to say here is that it should be from times immemorial, because what English people say that it should be from times immemorial, but we do not believe in that immemorial kind of a thing. But of course we do believe that it should be ancient and antique. Second is it should be, in continuity. There should not be any breakage. If there is a breakage in between, you are following custom, and then there's a breakage, and then again you say that there was a custom, we will not consider it as a custom. It has to be ancient, it has to be continuous, it has to be perpetual in order to be accepted. Then it should not be uncertain, it should be clear, it should be unambiguous, it should be, it should not be opposed to public policy, it should not be immoral. Of course, morality has not to be decided by a few section of people, it has to be decided by the whole community, that whether it is immoral or it is not immoral. And then the last one is, of course, it should not be opposed to the provisions of law. I have already stated that if the law is there and the custom is also there. It is the law, because in the section 4 we have already discussed, and section 4 specifically and explicitly it has stated that anything which is inconsistent with the provisions of law, whether it's a custom, whether it is any provision of law, if it is inconsistent with the provisions of the Hindu Marriage Act, it has to go away. It is the provision of this act which will now be applicable and which be applicable on the people. Modern sources, these were the ancient sources. We have 3 modern sources, and the first one is judicial decisions of precedents. Again, it's a very important source of law. Whatever decisions are being given by the courts, we know that they become precedents for the future ones. So whatever decision, so if there is something is missing, the judges, they interpret it and they decided. So this again became a very important source of Hindu law. We know that the decision of Supreme Court, whatever decision the Supreme Court gives, it's binding on all the courts within the territory of India. But if it's a decision of the High Court, it has it's binding on that particular state, but it has as far as the country persuasive value when you talk about the other high courts of India. So Supreme Court, its decisions are binding on all the courts within the territory of India, but High Court's decisions are of different states. It has a persuasive value. That means you can accept it, you cannot accept it. But the decision of the Supreme Court is binding and it needs to be accepted. It has to be accepted. Then, apart from this, legislation is another important source of law. We have a lot of, Hindu law is basically a codified law. There are a lot of acts which have come into picture. There are a lot of amendments that have taken place because we need to change as the society progressed. So whatever the laws that were earlier there, maybe they are not suiting in the present society, and that is the reason, in order to cope up with the present society, we do go for amendments. So a lot of legislations are there, and due to these legislations, it is also an important source of Hindu law. For example, some of the important legislations, it could be Hindu Widows Remarriage Act 1856. It basically, there are so many women comrade legislations, and Hindu Widow Remarriage Act again is one of the women comrade legislation which talks about widow remarriage, because earlier remarriage of the widow was not allowed, but this is the act which started and which talked about the remarriage of the widow. So in a way, it was trying to perk up, it was trying to boost up, it was trying to ameliorate the position of the women, because earlier they were not allowed, the widows were not allowed to go for another marriage, but this act talked about widows remarriage. Special Marriage Act 1872 has been repealed. It was earlier there. We have now Special Marriage Act 1954, and it talks about marriage that take place between different religions. In Indian Majority Act, we know that it talks about the majority age, and that is 18 years of age. Guardian and Wards Act, again it is talking about guardianship. It is talking about the welfare of the minor is paramount. It's very important. So it talks about these provisions. In Succession Act, it talks about wills, and again a very important one. Child Marriage Restraint Act has been now repealed. Now we have Prohibition of Child Marriage Act 2006. Earlier, this was also called as the Sharda Act, and it, as far as the child marriages were concerned, they were considered to be the valid marriages. Although punishments were there for in-betweeners, for negotiators, for the parents, for the guardians, but if the marriage took place, it was considered to be a completely valid marriage. This act has now been repealed, and in place, it's the Prohibition of Child Marriage Act 2006 that has come into picture. And there are a lot of very important provisions of this Prohibition of Child Marriage Act, and which I will be discussing later on when I will be talking on section 5 and we talk about the criteria of age. So I'll be dealing during that part. Hindu gains of learning, and again it says that it's through your labor, it's through your skill, it's through your diligence, that whatever you earn, that is your self-acquired property. It's not ancestral property. We know that there are different types of property, ancestral property and self-acquired property. So it basically talks about that when you are earning anything out of your own skill, your own labor, it's your hard work. So that means whatever property you are acquiring, that's your self-acquired property rather than the joint family property or co-pastory property. Then again, it's Hindu married women's right to separate residence and maintenance. It has been taken, the place has been taken by Hindu Adoption and Maintenance Act. It talks about certain provisions where women can separately live and claim residence and maintenance from her husband. We have special marriage, I have already told about this. Hindu Marriage Act, we are already discussing. Hindu Minority and Guardianship Act, it talks about the guardianship, and the various types of guardianship, various powers of guardians, so on and so forth. Hindu Succession Act, it talks about your property rights, and it is the one which basically an amendment has been made, and now we have Hindu Succession Amendment Act 2005, where daughters have also been included. Earlier it was only the males, although it talks about majorly on the self-acquired or separate property of a person, but now amendment has been made. The section 6, it also talks about this joint family concept, and the co-pastory has been included under it, and now daughters are also co-partners. So that would be we would be discussing later on. Hindu Adoption and Maintenance itself is speaking that it talks about adoption and maintenance. There are certain various provisions. Marriage Laws Amendment Act, again another legislation, a very important legislation which had introduced the concept of divorce by mutual consent, which is very much in vogue these days. We know that there are so many litigation cases and divorces are taken place, and which is mostly people are going for is, and it's the easiest way to take divorce, that is divorce by mutual consent. Under this Amendment Act, mental cruelty was also added, and the ambit of mental cruelty is very, very wide. Because of mental cruelty, so many cases have come up. It's not only, we know that cruelty is not only physical, it can be mental also. And if there is a mental torture within your marriage, you can move to the court and apply for divorce or judicial separation, as the case may be. That we will be discussing it later on. Amendment Act, I have already talked about that daughters have been included now. They are co-partners and they are placed at par with what the sons have been placed. So now there is no demarcation as far as the rights of the son or the daughters are concerned, as far as the ancestral property is concerned. Then the last source is equity, justice and good conscience, and it is considered to be the modern source, and due to insufficiency of laws, this was passed. The judges used to give their decision based on equity, justice and good conscience. That became an important source of Hindu law. And the last that I would be dealing here is the schools of Hindu law. We know that there are two major important sources, schools of Hindu law. The one is the Mitakshara and the other is the Dayabhaga. Mitakshara is applicable throughout India, and Dayabhaga is applicable in few states, for example in your Assam and it's a Bengal. So these are the states where this Dayabhaga is applicable. It was based on propinquity, that is by blood relationship, that is Mitakshara. This is based on spiritual thing. And now we would be discussing them in detail when we will be talking about the schools, Mitakshara and the Dayabhaga. But now let me tell you one thing here is that now earlier they used to have different patterns for succession, but now it has been, it's a one, this thing, and they are governed by that uniformity. Mitakshara has sub-schools. It could be the Bombay school, it could be Dravid, it could be, so there are certain schools, but Dayabhaga do not have any schools as far as this is concerned. So that's, we have under Mitakshara, we know that co-pastory is there, and children up to 3 generations, the son, they're all co-pastors, they all have birthright in the property. But in the Dayabhaga, co-pastory for the first time, it comes into existence only after the death of the father. Till the time the father is alive, he is an absolute owner, whether it is self-acquired property, whether it is co-pastory property, he can dispose it of the way he likes, but the same scenario is not there under your Mitakshara school. That we will be studying in my other lectures. I would be discussing these in detail. For this, as of now, we are through with this first my lecture. I will be dealing with the other things in my later lectures. Thank you so much for attending, and thank you so much.
Hello, I am A.K. Sharma and I teach sociology in IIT Kanpur. I am attempting to answer a simple question, what is sociology? Now friends, one simple answer would be that sociology is a study of human behavior. And this study of human behavior has a history. Actually, due to growth of science, technology and due to industrialization and economic development in the West, initially there was a hope that by application of science and technology, the face of this world can be changed to the advantage of mankind. But what was found or what was observed, that this did not happen. And despite economic development, urbanization, industrialization, surveys showed that poverty had increased, unemployment had increased, even health conditions became worse. And today you will be surprised to know that there was a time when death rate of urban areas was higher than the death rate of rural areas. Cities or the places of development, industrialization and education and enlightenment became consumers of rural population. So, people started asking why is it so? And some philosophers, engineers, mathematicians who contributed to emergence of a discipline like sociology started thinking that perhaps we need a new subject in which we will apply the same tools and techniques which are being used by scientists, mathematicians, physicists, chemists, but we will study human behavior. In other words, we will try to discover if there are laws of human behavior, and by applying those laws perhaps in the future the condition of mankind can be improved. This is how sociology developed. Initially Auguste Comte called this social physics. He also used terms like social statics and social dynamics, the usual division of mathematics, and he believed that social statics will study relationship between different parts of society and social dynamics will study relationship between parts of society and total society, change in total society. Now, you may ask that if sociology is the study of human behavior, there are many other branches of social sciences which study human behavior, economics, anthropology, psychology, etc., etc. The difference between sociology and these disciplines is that while in these disciplines we study one specific aspect of human behavior, like economics will study production and distribution of wealth, psychology will study cognitive processes or mental models or personality, social psychology will study personality, anthropology will study culture. Now, somebody has to relate one aspect of human behavior with the other aspects or one social fact with the other. These are all social facts for us. And if somebody tries to link cognitive processes with economic conditions or urbanization or caste system or religion, or somebody tries to relate urbanization with human psyche, or somebody tries to correlate cultural context with economic behavior, then it becomes sociology. So, sociology combines different areas which are individually studied by different disciplines. And sociology also studies new questions which are not studied by any existing subject so far. So, like these days issues of waste disposal, entropy, environment, safety, urban places as new geomorphological systems come up, and we want to correlate one aspect of urbanization, say percentage of population living in urban areas, and risk, environmental risk, carbon dioxide, this emission, that emission. Now, which will be the first discipline to take interest in these things? Because sociology. So, sociology not only combines facts from different aspects of society, sociology also addresses new questions. And I can also say that one central feature of sociology is to explain individual behavior or individual psyche in terms of properties of larger society. In simple terms, if you imagine that there are two aspects of human behavior, individual and society, then while other disciplines like psychology are focusing more on individual, we study characteristics of individuals in terms of certain characteristics of larger society. This is what sociology does. Sociology is very useful for planners. Sociology is useful for answering new questions, as I said, which have not been answered by any existing discipline. And I would say that sociology is especially helpful for self enlightenment or for developing empathy, because sociology only tells you that there are no right or wrong answers of social issues. It is not physics, it is not mathematics, it does not have fixed answers to issues, because questions can be looked at from variety of perspectives. So, role of perspectives, thinking, interest, power, etc., also come up in answering social questions. And it is this aspect that something can be looked at from variety of perspective, that something can be looked at from the perspective of government, the same thing can be looked at entirely differently from the perspective of people or from the perspective of NGOs or from the perspective of experts. So, this realization, this takes us to self enlightenment and empathy. Thank you.